Welcome to Plain Civics. Thank you for joining us. I'm Joe Ulery.
And I'm Bobbi Fisher.
Our goal is to break down how government works so you can make the government work for you.
In our continuing short series, we present the civic virtues that one of our most significant founders, Benjamin Franklin, thought to be the most important. He thought these civic virtues, or qualities that help individuals become better people and contribute to a stronger society, mattered just as much as public action. As we work our way through these, think about how these civic virtues track in your own life. The 11th civic virtue is tranquility. Franklin said, quote, "Be not disturbed at trifles or at accidents common or unavoidable," end quote. Were there moments when you stayed calm? How did it help you or others?
Tranquility, serenity now.
Yeah, we only have two more to go.
Two more virtues. And we're back to basics again today, and we're talking about what is rule of law.
And now our feature presentation.
Rule of law is the principle that both those who govern and those who are governed must obey the law and are subject to the same laws. The rule of law requires an independent judiciary that is immune from political or other manipulation. Put simply, rule of law means that every member of society, even rulers, must obey the law. Sometimes the phrase is presented as, quote, the supremacy of the law, end quote, because it means that rulers must base their decisions on known principles or rules or laws instead of their own discretion. This is different from rulers who might exert their power in arbitrary and careless ways based on unconstrained will and without regard for established law. This would be the principle of, quote, rule of men, end quote, in which those in power make up the rules as they please. Let's examine the history of the idea of rule of law and why the framers of our Constitution decided that rule of law would work better than the rule of men. When looking at the origins of the rule of law, historians and philosophers usually give one of two answers. The first answer focuses on the conceptual content of the phrase. At a minimum, the rule of law expresses an ideal of political morality, with Jeremy Waldron, author of The Concept and the Rule of Law, who said, quote, that people in positions of authority should exercise their power within a constraining framework of public norms rather than on the basis of their own preferences, their own ideology, or their own individual sense of right and wrong, end quote. This conceptual idea of the rule of law can be traced back to ancient Greece. Later, we see that Roman law, medieval political theology, early modern English political philosophy, and the French and German Enlightenments all enriched and complicated the conceptual inventory that scholars and jurists have come to associate with the English phrase, the rule of law. The second answer is more basic, that the use of the rule of law to denote a particular and preferable way of governing only entered mainstream legal, political, and philosophical discourse in the late 19th century. British jurist Albert Venn Dicey's Introduction to the Study of the Law of the Constitution, first published in 1885, is said to have contained the first notable modern formulation and analysis of the rule of law in a liberal democratic system. So Dicey is given credit for popularizing the phrase rule of law. And I want to stop for just a second there and go back to the term I just used again, liberal democratic system. I know I've mentioned it before, but I don't want people to get caught up in the term liberal. In this case, what they mean by liberal democratic system is it means that individuals' personal and private rights to liberty are the focus.
And when did liberal become it has a connotation to it now, but I don't know that liberal always was viewed as this horrible thing.
Right. So, but I wanted to make sure people understood that we're not talking about, liberal and conservative here. We're talking about how it relates to our individual liberties and protecting those. The earliest conception of rule of law can be traced back to the Indian epics Ramayana and Mahabharata, I hope I pronounced those correctly, which date around the 8th or 9th centuries BCE. One verse in the Mahabharata states, quote, "The people should execute a king who does not protect them, but deprives them of their property and assets, and who takes no advice or guidance from anyone. Such a king is not a king, but misfortune." end quote.
Yeah, I'm reminded of two quotes, Bobbi, that just are floating around my head and I wrote down. One is, with great power comes great responsibility, and heavy is the head that wears the crown.
Very good.
Those are just floating around in my head right now.
Very relevant. The first evidence of a European society governed by law, where rules were written and publicly accessible, can be found in ancient Greece in the late 7th and early 6th century BCE. You may have noticed I used BCE instead of the BC, which is the old-fashioned term, which meant before Christ, because AD, which we'll talk a little bit more about later, stands for Anno Domini, in the year of the Lord. So our earlier historical timings were based on what was thought to be his birth date. But about, I would say, 20 years ago, academics decided to make it a more secular way to denote where these centuries fall. So BCE stands for before the Common Era. It's the modern secular alternative to BC, the traditional term used to estimated birth of Christ. Once the laws were written and publicly accessible, Greek laws were no longer subject to arbitrary interpretation by a privileged class. The city-state of Athens is known to have had several versions of, quote, equality of laws and equal application of the laws, end quote. But this equality was only given to adult male citizens, not all members of Greek society, not women, slaves, or foreigners. Right. Sound familiar?
Very.
The ancient Greeks were respectful of their laws. Herodotus said, quote, although free, were not free in everything, they had a master, namely the law, which they feared, end quote. Aristotle argued that while a perfect world would not need laws, in an imperfect world, justice, quote, could only exist between those whose mutual relations are regulated by law. And you may find out later in this, and I've used the Madison quote before, it sounds very similar to what Aristotle argued here, that a perfect world would not need laws. Just kind of listen for that as we go a little further. It seems that the ancient Greeks believed that the proper purpose of laws was to advance the common good, but they also realized that too often laws were written to advantage the privileged classes of society. Ancient Greek philosopher Plato thought the rule of law was an inferior alternative to rule by men, or philosopher kings, who were to be guided by their perfect knowledge of the good. In contrast, later Greek philosopher Aristotle argued that because of the inevitable infirmities of rulers, and infirmities, think of it as imperfections or deficiencies, that because of those infirmities, the laws should be sovereign or have the supreme power or authority, not the person. He said, quote, we do not permit a man to rule, but a law, end quote. Aristotle flatly opposed letting the highest officials wield power beyond guarding and serving the laws. In other words, Aristotle advocated the rule of law. The rule of law was less prominent in ancient Roman thought after Rome changed from a republic to an empire around 27 BCE. When that happened, its laws were no longer adopted by popular consent, but were then dictated by the emperor. Despite this, some early Romans defended the idea of rule of law. The Roman statesman Cicero is often cited as saying, quote, we are all servants of the laws in order to be free, end quote. Cicero also held that Roman laws, even if wrong, should still be respected. Cicero and Marcus Aurelius both emphasized that laws should be both general and regular, or a universality of law, or, quote, a state with one law for all, end quote. Even though the Roman Empire was ruled by an emperor with absolute power, it did still have one important contribution to the rule of law, the creation of a legal profession. The Roman legal system was well-functioning, distinguished by accessible and impartial courts, which I found that interesting, that although they didn't necessarily have what we think of as rule of law, they still had courts that we would look at as pretty fair. With the decline of the Roman Empire by 500 AD, Western Europe was thrown into what is known as the Dark Ages, from about 500 to 1000 AD. And here we got, of course, the Anno Domini, which is the AD. Today, you'll probably see instead of AD, CE. For the Common Era. So we have BCE, before the Common Era, and CE, the Common Era. So get used to those if you see them in writings.
Yeah.
A lot more times it's the secular way to denote it. This period of the Dark Ages was marked by much migration, barbaric invasions, and fragmented kingdoms. The Catholic Church became the primary source of institutional continuity, legal memory, and administrative expertise for the unstable post-Roman kingdoms of Western Europe. In 800 AD or CE, Pope Leo III crowned Charlemagne as Holy Roman Emperor. Europe then saw 2 centuries of what were known as the Crusades, or Holy Wars, which were meant to try to retake what is today known as the Middle East from the Muslim states that occupied it. Feudalism, the decentralized network of governance based on land ownership, mutual obligations, and local authority, or if you want to think in simpler terms, the time of kings, lords, knights, serfs, and peasants, reached its height by 1300 AD or CE. Following the Mongol invasion, the Great Famine, and Black Death of the late 1200s and early 1300s, Europe then experienced a huge decline of population. Before this decline, during the reign of King John in England in 1215, the Magna Carta, or Magna Carta is Latin for Great Charter, was signed. This document was drafted to make peace between the unpopular King John and a group of rebel barons. Its importance is that it established the groundbreaking principle that everyone, including the monarch, is subject to the law, protecting subjects or citizens from illegal imprisonment and guaranteeing the right to justice. It failed at keeping the peace in England, but it established 2 enduring principles of modern law: the rule of law and due process. The end of the medieval period was followed by a cultural renaissance, and renaissance literally means revival or renewal. The Renaissance was an intense period of European cultural, artistic, political, and economic rebirth following the Middle Ages. It lasted from about the 14th through the 17th centuries. The era bridged the gap between medieval times and the modern world. It was characterized by the rediscovery of classical Greek and Roman philosophy, literature, and art. Europe was also in the midst of an industrial revolution with the inventions of the printing press, navigational tools, gunpowder, and other important scientific discoveries. Along with this, several European countries set out on voyages of discovery, which usually resulted in colonizing faraway lands. The printing press revolutionized how information was created, preserved, and circulated. This resulted in a renewed interest of the past and people studying past cultures and rediscovering ways of life and governing. Also, the Protestant Reformation, a major 16th century religious and political movement in Europe, splintered Western Christianity and created Protestantism, ending the monopoly of the Roman Catholic Church. This movement caused several devastating religious wars that shifted political power away from the papacy, or with the Pope in charge, and greatly influenced modern concepts of individualism and religious freedom. Many historians credit the Reformation as a key factor in the development of the state system, modern bureaucracies, poor relief and social welfare, and the legal tradition. So there's the tie. We have circled back around as the media revolution caused by the invention of the printing press helped spread ideas throughout Europe and beyond, and as ideas spread, people were also becoming more curious about the past, which helped to revive ancient ideas, especially about governing, which leads to the importance of the rule of law.
The printing press was, my goodness, it was seismic.
Exactly.
And it really did shake up and change everything and dynamics. And the first Bible was printed in English, King James. Had that done after that was one of the first things that they distributed in English, because I believe everybody was relying on priests for translation of the Bible, which was written in Latin. So now people could get a Bible and read it for themselves to see what the scripture said.
And I wonder how much that ties in. I'm just thinking off the top of my head with like Latin kind of, I mean, I know you can still learn it, but kind of dying out as the language of the time.
Yep. But it's sort of like social media and the internet hit. I kind of compare that, how it shook up the world.
I was, thinking that as you were talking about that. Yeah. The printing press,
Yes, it was a huge deal. So, all right, let's go into our history class, Bobby.
Don't know much about history.
Okay, this is our Don't Know Much About History segment. This was the largest city in the 13 colonies in 1776, with a population of around 30,000 people. It was also the unofficial capital of the colonies. Delegates from the 13 original colonies met here repeatedly, as it was a midpoint between North and South. The First Continental Congress met in Carpenter's Hall, September 5th to October 26, 1774, in a secret meeting of delegates from 12 of the 13 colonies to list the grievances against the Crown. This occurred in the year between the Boston Tea Party and the battles of Lexington and Concord in Massachusetts, which officially started the Revolutionary War. The Second Continental Congress met in Independence Hall, May 10, 1775 to March 1, 1781, as the governing body of the young United States. This body appointed George Washington as Commander-in-Chief of colonial forces in the Revolutionary War and adopted the Declaration of Independence on July 4, 1776. The Constitutional Convention also met in Independence Hall, May 25th through September 17th, 1787, discussing, debating, and writing the new law of the land, also known as the U.S. Constitution, to replace the Articles of Confederation. This city became the capital of the United States for 10 years, from 1790 to 1800, while Washington, D.C. was under construction. We are, of course, talking about Philadelphia, Pennsylvania.
City of brotherly love.
Yes, lots of history.
Exactly. All right, so let's jump back into today's lesson, episode 38, Rule of Law.
By the early 1600s, especially in England, we see the law increasingly regularized, meaning that laws were being established, written down, and incorporated into jurisprudence. Some people may not be actually familiar with jurisprudence. It simply means the science or philosophy of law, so don't get too caught up in that. But that and in the courts, all of that was starting to be written down and put into actual written law in the 16th century.
And then it could be studied, and you have case law, and you start to build a library.
And that's where we're going here. In England, judges were expected to uniformly apply the country's traditional customs, known as the common law. It was kind of word of mouth before, but now it is, starting to be kept in writing, so it can't be disputed. By the beginning of the 17th century, Chief Justice Sir Edward Coke asserted the power of the courts to decide legal questions even against the will of the government, with the common law, quote, controlling acts of Parliament and sometimes judging them to be utterly void, end quote. England also saw the rule of law given political effect through Parliament gaining the king's consent to the petition of right, which required the king to govern according to the laws of the realm, barred the application of martial law to civilians, and eliminated the king's power of arbitrary arrest without breach or breaking of a specific provision of the criminal law. In 1688, the English Bill of Rights justified replacing James II as King of England by William of Orange on the grounds that James II had, quote, endeavored to subvert laws and liberties of his kingdom by various acts, quote, utterly and directly known to the statutes and freedom of this realm, end quote. Things were still not always fairly carried out, as we see in the history of the American colonies, which were governed by England, and the reasons the colonists eventually decide to split from England by 1775. And those were summed up in the list of grievances in the Declaration of Independence. As the rule of law gained strength, it was given a clear analysis and theoretical justification by John Locke, an English philosopher widely regarded as one of the most influential Enlightenment thinkers. And again, we've talked about him numerous times. His theoretical defense of the rule of law was based on the idea that a government's legitimacy depended upon popular consent, or the people, because individuals would not consent to a government that would not offer them security, and a government ruling by arbitrary decrees would not offer such security, Locke concluded that a legitimate government must, quote, dispense justice and decide the rights of the subject by promulgated standing laws, end quote. Locke concluded that the rule of law must be decided by, quote, authorized judges, end quote, and not interested parties. Finally, given the necessity of popular consent, the legislature was not only bound to advance the common good, but could be replaced if it failed to do so. Think Declaration of Independence there. The principle was also discussed by Montesquieu, who we've also talked about before, in his The Spirit of Law from 1748. The phrase rule of law also appeared in Samuel Johnson's dictionary in 1755. Since the colonies were either established by England or eventually taken over by the English crown, leaders in the colonies were well aware of the English tradition of law and established their local governments using that tradition as a guideline. As we have established many times in our previous podcasts, the founders or framers of our nation's first governments and founding documents were students of these earlier philosophers, historians, and jurists. Rather than reinventing the wheel, the framers drew upon the wealth of knowledge the earlier scholars had left to them and their own experiences with governments as they were creating their colonial governments, the Declaration of Independence, the first United States government, and eventually the U.S. Constitution and Bill of Rights. So kind of we can go back and thank the Enlightenment and the Reformation, renewing all of that information from ages past. In Federalist Paper number 51 in 1788, James Madison said, quote, if men were angels, no government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and the next place oblige it to control itself. So there's that tie into the Aristotle quote from earlier. Madison's quote from the Federalist Papers gets at the heart of the problem, that even a government of law is ultimately administered by men over men. The framers of the U.S. Constitution address this problem by dividing power among the different branches of government, the legislative, executive, and judicial. This framework for government, known as the separation of powers, ensures that no one person is able to gain absolute power and stand above the law. Each branch of our government has some level of control or oversight over the actions of the other branches. The rule of law, however, does not depend upon a U.S. style of government. For example, in a parliamentary system, the powers of the executive and legislative branches are combined. Procedures such as, quote, no confidence votes and regularly scheduled elections serve as a check on the party that controls the parliament. The key point is that every form of government has to have some system to ensure that no one in the government has so much power that they can act above the law. It is very difficult for a nation to maintain the rule of law if the citizens do not respect the law. Assume that people in your community decided that they didn't want to be bothered by traffic laws and began to ignore stop signs and traffic signals. The ability of police officers to enforce the laws would be overwhelmed, and the streets of your community would quickly become a chaotic and dangerous place. The rule of law functions because most of us agree that it is important to observe the law, even if a police officer is not present to enforce it. Our agreement as citizens to obey the law to maintain our social order is sometimes described as an essential part of the social contract. This means that in return for the benefits of social order, we agree to live according to certain laws and rules. If too many people refuse to agree to this social contract, what results is anarchy or chaos. You know, if you don't follow the law and you get caught, you have to have some kind of punishment or
accountability.
Yeah, for that. So,
yeah,
and that hopefully, makes people in the future maybe
more accountable.
Follow the law. Yeah.
And I like to think as I sit out in the driveway with neighbors and watch people run stop signs, it's like, what will you do or what do I do when nobody's watching? I think that's important what you do in those moments. I still come to a complete stop. I do. I always feel like somebody's watching me, as the old song goes. But it's a fair question. What do you do when nobody's watching you? Do you do the right thing or do you do the wrong thing?
And as I was typing that part, I thought, oh my gosh, like one morning on my way to work a month or so ago, within the matter of like 5 minutes, I saw two people completely disregard not a stop sign, but a stop light. I mean, one was turning from one road to the other, and my way had the right of way. And I suppose they did have time, but it was close. But they
Yeah.
just pulled right. They didn't even make an attempt to slow
Yeah.
down.
And it's complete disregard for everyone's safety. I mean, you talk about if everyone stopped observing the laws, but you saw with just two people, it becomes dangerous.
Right.
Like, you know what I mean? Somebody could have gotten T-boned. And even if your light's been green for 10 seconds, if somebody going the other way decided to run a red light, they cut right into you.
And I think too, like I work in Lafayette sometimes, and I know everybody even that lives there would agree. Creasy and 26 or South Street is the absolute worst intersection there. I sit there because that's how I get to my place to work. I've sat there and counted numerous times 5 to 6 people that have the turn arrow will go ahead and turn even after that's turned red.
Of
And
course.
it's like they're just hoping that, they're disobeying the law and hoping that other people are going to
stop,
wait, so that they can. It's like,
which is rude.
Yeah,
it's so rude. And if something were to happen and there are witnesses, they're going to be the ones held responsible.
Exactly.
Yeah.
But it's like, I'm going to play chicken with you. And, it's
crazy.
caused, like you said, at high traffic times, you could be like third car back and not even get to turn on that light because so many people ran
or they're stopped in the middle of the intersection
right.
because they didn't want to get boxed in. And now they've stopped traffic and they're creating gridlock.
Especially when Caterpillar is just let out. That's but yeah, so we do depend on people to follow the laws. And like you said, they have to recognize that if they are caught, there are going to be some consequences.
Absolutely.
And but it's all part of this social contract that we agree to. Judicial independence means that judges are independent from political pressures and influences when they make their decisions. An independent judiciary is essential to maintaining the rule of law. Judges should not be pressured by a political party, a private interest, or popular opinion when they are called upon to determine what the law requires. Keeping the judiciary independent of these influences ensures that everyone has a fair chance to make their case in court and that judges will be impartial in making their decisions. Judges also must explain their decisions in public written opinions, and their decisions can be appealed to a higher court for review, unless it's, of course, already at the Supreme Court. These elements of judicial decision-making ensure that judges remain accountable to the rule of law. In conclusion, our democratic republic cannot exist without rule of law. It is part of the social contract that we all agree to follow the given laws in return for protection by the government. The laws must be reasonable and enforceable and are enforced equally and impartially. The laws are made and enforced by established procedures, in our case, the Constitution, and not the arbitrary will of a ruler. The rule of law is an essential characteristic of every constitutional republic that guarantees rights to liberty. It exists when a constitution functions as the supreme law of the land. I would also point out that a functioning rule of law system likely depends on some level of free expression. Without a free press, it becomes much harder to hold officials accountable or know whether the law is being followed. If any of these factors begin to break down, the stability of the government and nation becomes threatened. So we must do everything within our control to make sure our laws are followed by all, including those serving us in our government.
All right, so where are we headed next?
So next episode, we're going to be talking about our semi-quincentennial, or America at 250.
Yeah.
What are we celebrating? What's it all about? Why is it so important? The Declaration of Independence is part of that, of course. But I think a lot of people just kind of take it for granted and sometimes don't actually stop to think what we're really celebrating. And of course, it is amazing that we've been able to do this for 250 years. We're almost there.
Yeah, and hopefully we can do it for another 250. So the 4th of July, is that the actual date?
It's the date they verbally agreed to the Declaration. However, it wasn't signed until August 2nd, I believe. And I also want to point out here, just to show how old I am, I graduated high school in the year of America's bicentennial.
Was that was that 1970? I almost said 1776. Was that 1976?
It was 1976. I have my 50th reunion in a couple weeks.
So what do you remember from 1976 of our collectively celebrating as a nation?
And of course, our class being that bicentennial class, and our school colors were red and blue anyway, so we had a lot of patriotic looking stuff. But as a nation, I just remember there were lots of celebrations that went on. And of course, this is before the internet and everything.
Yes.
So, it was more of what I would think of people today would look at as kind of an old-fashioned way of celebrating.
So that was 1976 AD, right?
Or Common Era,
yes.
CE.
CE. Yes, got it. All right, so let's move on to the pop quiz.
Last episode's question: under our Constitution, some powers belong to the states. What is one power of the states? And I listed a few here, but I kind of gave hints when I gave the question. A lot of these things have to do more with our everyday life than the question we had before, which were what are some of the powers of the federal government. So state governments provide schooling and education, or public education, provide police protection. And of course, again, there are different layers of some of these things. So the federal government does have police protection, but it's, we're talking about our local police and our state police. They're the first levels. They provide safety, our fire departments, for example, or emergency management.
Yep.
You get your driver's license and your marriage license from the state, and they establish the rules like how old you have to be to get a learner's permit and to get married and all that. Those are all state zoning and land use. That's local or state power. So more things that control us on an everyday basis.
Yep. So the question for this episode:
who is the governor of your state right now? Now, obviously, answers are going to vary.
50 different answers.
And we won't be able to give them all, but but just kind of a food for thought. And if you were taking the naturalization test, you could be asked, who's the governor of your state? It is good to know who your governor is and who your local state representatives are and your U.S. representative and senators. Those are important things to know.
And if you don't know them, I would encourage you or challenge you to actually look those up. Reach out to them. Let them know what you're thinking. Sometimes they love hearing from you when you agree with them, and sometimes they don't enjoy hearing from you. But I guarantee you the phone call or email you send does make a difference in the totality of how they're working.
And regardless of whether they agree with you or not, they are supposed to be serving us, so they should at least take into account our views.
Exactly. All right, Bobbi, thank you for all your hard work this week on getting this episode together for us to record today. Next, episode 39. That's it for this episode of Plain Civics, breaking down the basics. No politics, just facts. Thanks for listening. And until next time, stay informed and stay engaged.
This is Plain Civics. Join us for the journey as we break down the basics of how government works, so you can make the government work for you.